my presentation is called International Criminal Justice 27 Years Down the Road, Aspiration and Realities. And what I will do, I will give you a brief history of international criminal justice. Then I will discuss a little bit why I think that international justice is special. I think that there is something special about international criminal justice. Then I will discuss aspirations of international criminal courts and tribunals and how these aspirations are actually met with harsh realities and what the challenges in the practices of prosecuting the core international crimes are. And I will conclude with one slide relating to the topic of the course, which is serious economic and environmental crimes. So give you a little bit of a sort of overlap between international criminal justice and economic and environmental crimes. So international criminal justice, just start very much from the basis. I think that if we talk about international criminal justice and look back in history, there are basically three stages what happened in the modern history of international criminal justice. We started in the 1940s with the Nuremberg and Tokyo paradigm. So after the Second World War, the Allies actually were wondering what to do with the Nazi and Japanese criminals, whether to execute them or try them, and in the end actually the trials won. So these were basically the first international criminal tribunals, and they tried Nazi and Japanese elite for crimes against peace, war crimes and crimes against humanity. And they are both criticized as victors' justice because indeed allied crimes did not appear in front of these tribunals. However, they are still considered to be the pioneers of the modern international criminal justice. And also contemporary tribunals are basing themselves very much on the jurisprudence of these courts. During the Cold War, nothing was happening. And after the Cold War, actually, there was a renewed international cooperation, new world order and optimism. But the security balance that actually was established during the Cold War sort of fell apart, and many wars, especially within nations, started, and there were many crimes committed. And at this time, a United Nations Security Council actually unprecedentedly reacted to these crimes by establishing ad hoc international criminal tribunals for former Yugoslavia and Rwanda. And these were established under the United Nations Charter as a measure to restore peace and stability. However, they had a lot of troubles functioning, especially in the countries to which they pertained to. There was a lack of support. So I think that over the 90s, actually, this strictly international model changed slightly to the internationalized model, meaning that international community actually together with the state where the crimes were committed, established a tribunal. And these courts were established for Sierra Leone, Cambodia, or Lebanon, for that matter. And in the 2000s, we have the International Criminal Court, so the permanent ICC paradigm, as I call it, which is consensual. It's a treaty, so states can accede, ratify the statute, and then become parties to the statute. And the ICC is aspiring to provide universal or global justice. What is also important here is the importance of domestic courts. ICC is based on complementarity principle, meaning that the domestic courts are the primary ones who should try international crimes, and only when they are unwilling or unable, the court can step in. And I think there should be perhaps one more stage, which is, I don't know, 2010 and further, where I think due to the challenges of functioning of international criminal court and other tribunals, but also changing political circumstances, I think there is more and more shift to domestic solutions. So we are sort of going away from the international optimism and solution to these crimes and looking more towards domestic courts. And another thing which I think has been happening recently is that there is perhaps more open mind to different solutions than criminal trials. So many other sort of initiatives to tackle and deal with these crimes are being pitched and implemented around the world. So this is sort of a very brief history of international criminal justice. And I have created, and I always put it in my presentation because I created it once and I'm very proud of it. This is a map of international criminal justice where you have all the tribunals that have been established since 1990s actually. and the states to which it pertains to. I'm not going to go through all of them, but I think what you can already see is that international criminal justice is very selective. It's very selective in what situations, what crimes actually come to its purview. So these are the institutions of international criminal justice. They are sort of like a criminal courts, and one can say that they are typical criminal courts, but are they? I don't think that they are. I think that there are special features which pertain to the crimes international criminal courts and tribunals deal with, perpetrators of these crimes, but also the context in which these tribunals operate. And I'm going to mention a couple of these specific features which I think distinguish international criminal justice from domestic criminal justice. So what are international crimes? I'm sure that all of you are familiar with it. International crimes are crimes which basically can be divided into 4 categories: genocide, crimes against humanity, war crimes, and aggression. Aggression stands a little bit apart. But if you look at genocide, crimes against humanity, and war crimes, these are they all have the same underlying crimes, such as murder, rape, or plunder. These are oftentimes violent crimes, and what distinguishes them from normal murder or rape is the context. So legally, there are specific contextual elements which sort of elevate a murder or a rape from ordinary murder to murder as a genocide, crimes against humanity, or war crimes. For genocide, this specific element is a special genocidal intent, so the murder has to be committed with the intent to destroy a specific group. For crimes against humanity, it is the context of systematic and widespread attack against civilian populations. For war crimes, it's a context of armed conflict. So legally, there are clear sort of elements which distinguish these violent crimes from ordinary domestic crimes. And criminologically, there are also differences, I think. So as I said, usually these acts are violent, and they are committed within special political and societal context. And this context usually is constituted by wars, civil uprisings, repressions. And for criminologists, this context is actually very important in order to explain who commits crimes and why. So context, actually the fact that like the societal relations are broken and groups are fighting each other, is oftentimes considered determinative of criminal behavior. What is also important is that these crimes are usually large-scale, systematic, and often state-sanctioned and tolerated, which also sort of means that for criminologists or also all those studying these crimes, actually everything is put upside down. Because if you think about it, for normal crimes, state is usually the one who tries to prevent or punish violence. In international crimes, oftentimes actually state promotes or tolerates the violence. So that sort of makes the dynamics very, very different. And another thing which is also important is, especially for criminal trials, I think, is that because of all this, also the harm that entail or that is caused by these crimes is multifaceted, extensive, and long-lasting, which then makes it very difficult to squeeze it into criminal law categories. When it comes to perpetrators, and especially perpetrators in international criminal law, despite the collective character, which I just very, very briefly outlined, international criminal law deals with individuals and individuals acting with intent. So there is no jurisdiction over organizations, no institutions or states. So this is also important, I think, when you talk about economic or environmental crimes, because oftentimes for these types of crimes, organizations are responsible. And at the current state of affairs, these would not be able to be prosecuted at the international level. There should also, as in any other criminal law, be a clear link between the individual and the acts. So the causality and intentionality is very important. We don't have objective liability in international criminal law, which is also, again, sort of can be juxtaposed against environmental crimes, or environmental harm, which is oftentimes caused by, negligent conduct of many individuals. However, despite this individualized and intentional focus, the individuals which are tried by international criminal courts oftentimes act within hierarchical organizational structures. So there is collective perpetration and collective harm, which poses specific challenges for international criminal law. And I think in this sense, it's also important to sort of distinguish between leaders, who are the ones who sort of devise the policies and orders to commit international crimes and commit, as the criminologists call it, crimes of powerful, and followers who commit crimes of obedience. And oftentimes the argument goes that the followers would have not committed their crimes if it was not for the leaders. And this, in international criminal law, translates to discussion who is actually the most responsible. Are they the ones who actually sit behind their desks and never make their hands dirty? However, perhaps devise the context in which international crimes are committed, or the ones who commit terrible acts on the ground. So all this actually sort of creates a very, very complex reality, which is very difficult to be squeezed in criminal law terms and conditions. Another thing which is also important to realize is that sort of like the boundary between victims and perpetrators when it comes to international crimes is very blurry, because over time it can change. So victims become perpetrators, perpetrators become victims, and oftentimes a person can be the same at this or both at the same time. So there are very, very sort of difficult realities which law has, I think, difficulties to deal with. And finally, when it comes to context in which international criminal courts and tribunals operate, I think there is one thing which we need to realize is that they are a relatively new phenomenon. So they are, as I said, 27 years old. I am becoming 40 in 2 weeks, and I think I'm still very young. But compared to domestic criminal justice systems, this is like a really, really short amount of time that these institutions were operating. And I think that the current practice is still sort of characterized by many trials and errors, attempts and amendments of the practices, because they are sort of still trying to find their ground. Another thing is that they are dependent on states. They are international organizations. So they don't have direct enforcement powers, they don't have prison, they cannot arrest persons, which very much limits what they can do. And because of that dependence, they are highly politicized, I think, and they also deal with politically charged conduct, which makes it quite challenging to do it properly, let's say. Another thing which is important are limited resources, especially given the magnitude of crimes that they are dealing with. And I think that all this sort of determines the priorities and necessities of international criminal justice. What is desirable to prosecute and what is possible and feasible. And I think that this sort of determines their practices. And in addition to this sort of like a special crimes, special perpetrators, special context, I think there is another thing which distinguishes international criminal courts from domestic courts, and that is that they aspire to not only prosecute individuals and prevent and repress crime, but also do many, many other things. They sort of aspire to transform individuals, transform communities, transform global orders. So in contrast to domestic criminal courts, I think that the ambitions of international criminal justice reach beyond repressing, controlling, and preventing criminality. And these different aspirations can be divided into, I think, like 6 main themes. First, which is like the main core of their functioning, is to establish accountability. So they seek to try perpetrators in fair trials and punish them afterwards if found guilty, or acquit them if not. By punishing perpetrators, however, the tribunals also want to find truth and establish history so that the crimes cannot be denied. The third aspiration is to deliver justice to victims. Then, by doing that, they also want to prevent violence and crime, but also promote peace, rule of law, and democracy, And finally, they also want to bring perpetrators and victims together and promote reconciliation. So you can see that these aspirations are quite sort of sky high. They reach very high. And what I have done is actually, I have looked at empirical criminological scholarship and see what this scholarship, looking at functioning, effects, and consequences of doing international criminal justice, tells us about these different aspirations. And what I am going to do now is to discuss some of the challenges that have been identified by this scholarship when it comes to delivering each of these aspirations, like what are the realities of international criminal justice. There is one disclaimer though, the empirical scholarship when it comes to international criminal justice is not very well developed. I think that this field is still very much sort of based on wishful thinking and assumptions. However, there are some general findings or general challenges which have been discussed and identified by those who are actually looking what law in practice or applying law in practice does. So when it comes to establishing accountability, as I said, this is like the core function of the tribunals, and so far I think there have been over 160 individuals who have been convicted by all the criminal courts and tribunals together. About, I don't know, 20 have been acquitted. So in this sense, they sort of fulfilled this mission, but this also, of course, does not come without challenges. So the first one, and I think that you could have seen it already at the beginning of my presentation, is that these courts are politically dependent. So they operate, as John Hagan called it, in atypical political environments. So the prosecutors actually at these courts depart from the normal, usual criminal justice routines as we know them in domestic criminal system. So they choose their cases and evidentiary strategies, maybe not so much based on principle, but more depending on the immediate historical context and what is possible. And this is the quote which Antonio Cassese, who was like the first president of the Yugoslav tribunal, said at the beginning of its functioning, and I think it very nicely characterizes how tribunals function, because they are like armless and legless giants which need artificial limbs to act and move. If state authorities fail to carry out their responsibilities, the giant is paralyzed, no matter how determined its efforts. So the tribunals are highly, highly dependent on the states. There is no prison, there are no enforcement authorities, there is no police. They actually are sort of constrained by what states are willing and able to do. And there is a cartoon, which is a very famous one, actually, of International Criminal Court, which says, International Criminal Court, you are charged with evading world justice. How do you plead? And then the US says, bigger. So you see there is this always tension with the realpolitik and the interests of states which might not be aligned with the interests of international criminal justice. And all this also means that international criminal courts and tribunals are selective. So they are selective not only with respect to the situations and crimes they deal with, but also with respect to individuals who in the end up at these courts. And we oftentimes simply do not know why certain individuals end up at the international level and are tried there. So that's something which one needs to keep in mind every time when we discuss international criminal justice. However, even if the individual is the lucky one and ends up at the International Criminal Court and Tribunal, I think there are other problems. Another problem is, for example, delimiting harm and assessing culpability. And I think this one is also very relevant for environmental and economic crimes, because we are talking, as I said, about collective crimes which lead to multifaceted, very complex harms and are committed by many, many different individuals. And how to delimit harm and sort of ascribe it to an individual which is standing trial, I think is extremely challenging experience. I was currently last year, I was lucky to be able to help to write the sentencing judgment of Taganda, who was one of the offenders at the International Criminal Court. And I experienced it myself. It's just so extremely difficult, given the mess that these crimes are committed in, sort of to pinpoint what the person is held accountable for and what does it mean in terms of his or her culpability. I think this is like one of the biggest challenges of like international criminal trials. And finally, and that's very much related, is determining appropriate punishment. So we are talking about the most serious crimes of international concern, and you can never have appropriate punishment to these crimes. And indeed, if you look at the sentencing practices of the tribunals, the punishments that were handed out so far are very, very lenient. And oftentimes the tribunals are criticized for a sort of leniency of their punishment practices, especially if one takes into account the crimes that they are dealing with and compares it to domestic criminal justice system. So I would say that these are a couple of challenges when it comes to establishing accountability. When it comes to finding the truth, I think we have two types of truth which the tribunals ascribe themselves to be finding. The first is a judicial truth, and the second is historical truth. So when it comes to judicial truth, I already sort of mentioned a couple of times that it's very difficult sort of to square this narrow-minded outlook with the complex realities of the crimes on the ground. And judicial truth basically means that the judges want to establish who did what, to whom, when, and where, and how. So you would say that it's simple. However, in practice, it turned out not to be so simple, and there are a couple of reasons for that. The first one is that the international courts usually are sort of a mixture of different culture, different languages, people from different background, and what some scholars have shown is that a lot of fact-finding or judicial truth-finding gets lost in translation. It gets lost in translation on a very basic level, such as literally. So because the tribunals usually work with interpretation, and when you interpret something, I guess you know yourself that a lot of things can get lost. But also in terms of sort of culturally determined ways of seeing, reporting, and interpreting facts. So what, for example, Nancy Coombs have shown at the Rwanda tribunal is that oftentimes Rwandan witnesses were not able to sort of report details such as time or location in the detail and specificity as judges, Western judges, wanted them to, because in Rwandan culture they have different ways of talking about time and space, for example. So in this sense, there is this mismatch between this like criminal law, very precise Western-oriented focus, and then perhaps witnesses which come to the tribunals are not able to relate to these ways of thinking. And all this actually led Nancy Coombs to conclude that oftentimes actually the tribunals are finding fact without facts, because there are a lot of inconsistencies, a lot of sort of discrepancies between witness statements, and judges oftentimes actually explain it away in order to find facts. When it comes to historical truth, I think here it's important to realize that, yeah, the tribunals are courts, criminal law courts, and they are very much interested only about the individual who is on trial. They are not interested on why crimes have happened in general. So it is very much legally framed, very sort of under microscope look at history, and not the bigger picture that historians oftentimes, not oftentimes, but that historians are after. So the history that is sort of produced by the tribunals is very constrained and very sort of purposefully limited towards the individual. So you don't see all the other connections and issues that historians would be usually interested in. Another thing I think which is important here is that the history produced by the tribunals are oftentimes contested. So history is usually socially constructed, And it is sort of dependent on willing audiences. So people need to hear the history and accept the history. And some scholars who did research in the Balkans, in Bosnia, for example, have shown that the history that the ICTY produced is actually very much contested. And on the ground, there are 3 different histories, with each group sort of accepting the history where they are victims or heroes, and rejecting the history where they are labeled as perpetrators by the ICTY. So basically the history established by the tribunals is then sort of squeezed into a narrative which are very, very differing on the ground among different groups. So these are, I think, the main challenges when it comes to finding the truth. The next one is providing justice to victims. And this is actually one of the main justification and maybe the most emphasized aspiration of international criminal courts and tribunals. We are doing it for victims. However, I think that when you look at the research that examines sort of views and perceptions of victims when it comes to justice provided by the tribunals, it is not very optimistic. I think we can talk about 2 types of victims. We have victim witnesses, or those who actually are called to participate on trials. And there have been not so much studies sort of gauging perception of these people, but the general assumption is that whenever the victim or witness is called to trial, it leads to catharsis and contentment, which I think, not surprisingly, is not oftentimes or not always the case. And the studies that I have seen sort of portray a very mixed picture of some people being happy by testifying and being able to share their stories. But on the other hand, you have those who actually become very frustrated. They also become very frustrated after being sort of used by tribunal and sent back home to oftentimes not very cozy conditions. They become frustrated oftentimes after trial when the perpetrator is acquitted or punished with not sufficient punishment according to them. So there are a lot of factors which sort of determine victim satisfaction and whether the victim witness actually consider the justice provided by the tribunal to be justice. And another, I think, facets of this are victimized communities. So sort of all the victims, and as I said, these crimes are very large scale. So oftentimes the harm actually includes everyone, let's say, directly or indirectly. And there have been some research, some surveys done in many countries around the world, such as former Yugoslavia, Congo, and Uganda. And what these studies actually have shown usually is also not a very optimistic picture when it comes to the tribunals, because victims oftentimes do not prioritize having an individual on trial, but would rather get reparations, or they would rather live in more secure environments, or prioritize their health. So actually the priorities of victims oftentimes do not match with the priorities of the court. Another thing here is that the courts or the international courts are oftentimes very distant from the victimized communities. So, for example, I have done some research in Rwanda, and I came in as a naive sort of believing researcher in international criminal justice. And then when I went to the rural areas of Rwanda and wanted to discuss ICTR, no one knew about the tribunal. No one actually knew that the institution existed, what it did. So there is sort of like a total gap between the realities on the ground and the international criminal courts and tribunals. And finally, I think that the justice, which is, or I don't think, but the empirical studies have shown, and I think it also has been clear from what I have said by now, that the justice which is sort of provided by the courts is oftentimes contested in the post-conflict societies, and is oftentimes politicized. So this is very much similar to the history that I was discussing, that, and you see it, for example, in the former Yugoslavia, where basically any judgment which is rendered against your own group, not your or one's own group, then is contested by the politicians as unacceptable, inappropriate, or biased. On the other hand, if there is an acquittal, it is celebrated as a success of the tribunal. So you see that these environments where which the courts actually address are very, very complex as well. Okay, I sort of lumped up these very, very high aspirations of preventing crimes, promoting peace, democracy, and rule of law. And I think that these are, when it comes to empirical studies, so really trying to establish effects of the courts and their rulings, they are very difficult to study, because as in deterrence, in normal criminal law, it is very, very difficult to empirically establish causality. So there is some research which is emerging. The research pertains mainly to the International Criminal Court, and I would say that we can be sort of cautiously optimistic, because the research has shown that under certain conditions, actually ICC ratification, so meaning only adopting the statute, improves human rights, facilitates peace, reduces atrocities, and oftentimes actually it boosts prosecution of human rights violators. So going beyond actually atrocity crimes, core international crimes, and pertaining to other human rights. However, what is important to realize here is that oftentimes all these states where this improvement or facilitation happens are the ones who already were peaceful before the ICC functioned. Another empirical research, and this is always the case with, I think, quantitative studies, is that it always depends how you model you know, your model and which variables you put in and what is your sample, because other research actually showed that the ICC does not affect human rights, it hinders peaceful resolution of conflict, it does not prevent civil wars and prolongs dictatorial regimes. And, you know, I can go in depth into it, what are the differences between these findings, and they both stand. However, what is important to realize is that the conditions in which ICC operates and how it does always matters. And how these different effects are modeled very much depends on what the outcome is. So basically, what one can conclude is that the ICC indictments and other actions can alternately prevent, exacerbate, or have no impact on atrocities in the same situation over time. So therefore, I think that with respect to these high-level, very, very sort of fancy aspirations, the findings are inconclusive, very mixed, and piecemeal. And I would say that it's no surprise, because given the complexities of the tribunals themselves, complexities of the environment that they operate, it is very, very difficult to sort of test, isolate, and gauge any preventative or positive effect of tribunals on these huge notions. And I think that the similar empirical challenges sorry, it's not COVID. Similar empirical challenges pertain to measuring reconciliation, which is like the final aspiration of tribunals, emphasized oftentimes by themselves, because reconciliation is a very elusive concept. So we can talk about thin reconciliation, which means absence of violence, which in a way then overlaps with preventing crime, or thick reconciliation, which is then promoting friendly relationships and sort of people living in harmony together. And you can imagine that the second, especially the second understanding, is very, very difficult to measure or gauge empirically. But when it comes to research, there have been some studies which have tried to do it, but mainly with pessimistic results. And oftentimes tribunals are actually more divisive than uniting. And I think this comes as no surprise after everything what I have said by now. So all in all, and I am slowly wrapping up, is that these empirical studies, I think, and these sort of different pieces and snippets of looking at how the tribunals actually function and what effects they bring in societies where they are engaged, show us how challenging it is actually to prosecute core international crimes. And I think that in this respect, I think I agree with Guinea Metro, who is who is a professor at the University of Amsterdam, and also one of the very successful defense lawyers at the International Criminal Courts and Tribunals. I think that all his clients have been acquitted, if I'm not mistaken. And in one of his books, he wrote that it is hard to identify crimes which are more difficult to prosecute and sentence than international mass atrocity crimes. And indeed, I think the crimes are very difficult to reflect and be dealt with by any laws. And international criminal tribunals and courts already struggle with what they have in their dockets. And I am thinking, and this is something which I'm sure you will discuss in the upcoming days, is whether adding even more complex behaviors and harms, such as environmental crime or serious economic crimes, would not mean overburdening them and ultimately perhaps cause their sinking. So this is the question which I think you can think about in the upcoming days, where there are a couple of lecturers. I think James is going to discuss land grabbing. Mark Trumbull is going to discuss tomorrow environmental crimes, or Mikkel on Friday. And I guess that they will sort of address different aspects of including these environmental and economic crimes. And I think that what you can do is to have in the back of your minds everything what I have said now, and think about how it actually, or how it could work in practice. And before I wrap up, like final slide, which is linking this presentation to the topic of the summer school, and that's I think important to state that the economic and environmental crimes are not actually neglected even by international criminal justice as it now stands. So criminologists, green criminologists, have been studying environment and monies as well as a cause, tool, and victim of mass atrocity crimes. So not as a separate crimes as well, but as a possibility, as a sort of a means to commit these crimes, and as a harm which is entailed by these crimes. And I think that existing international criminal law actually make it possible to charge and prosecute, and I will talk about environmental crimes now, because, for example, when it comes to genocide, we can think of environmental cleansing. So changing, environment to such an extent that it inflicts on a group conditions of life calculated to bring about their physical destruction. And that's something which already at the International Criminal Court, I think in the Darfur situation, the prosecutor was also trying to do. When it comes to crimes against humanity, I think that James will address this afternoon land grabbing as a potential crime against humanity. And similar to genocide, actually attack on natural resources can be means by which various crimes against humanity can be committed, such as extermination, forcible transfer, or other inhuman acts. And when it comes to war crimes, that's actually the only provision in the Rome Statute of the International Criminal Court which explicitly addresses environmental crimes. It's Article A2B4. And it states that intentionally launching attack in the knowledge that such attack will cause widespread, long-term, and severe damage to the natural environment, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated, is prohibited as a war crime committed in international armed conflict. And I think this is something maybe that Mark Trumbull is going to discuss tomorrow. So, there are tools in existing international criminal law to go after environmental harm as international crime. Another thing which I think is important to mention is the 2016 prosecution policy paper on case selection and prioritization, where the prosecutor actually explicitly said that it will give a particular consideration to prosecuting crimes that are committed by means of or that result in the destruction of the environment, the illegal exploitation of natural resources, or the illegal dispossession of land. So there is a tendency of the prosecutor herself now to actually address these crimes. And finally, in this context, I think what is important to mention is the crime of ecocide, which will also be discussed, I think, in one of the lectures, which is sort of has been, not now, but for some time already being proposed as a new category of international crime. So irrespective of the existing categories, maybe harm to the environment as such should be conceptualized and adopted as a separate international crimes under the jurisdictions of international criminal courts and tribunals. Okay, so I think I have given you like a very basic overview, and all the others in the upcoming days are going to discuss much more sort of focusly and on point when it comes to prosecuting internet or environmental and economic crimes at international criminal courts and tribunals. And I think that you can keep at the back of your minds everything what I have said, and maybe interrogate the speakers a little bit as well. And by that, I thank you for your attention.
Thank you, Barbora. And I have to correct you a little bit. It wasn't a basic, but a very comprehensive overview, I would say, of the issues. And before commenting on the content, the rich content of the presentation itself, I can, as someone who has just turned 40, I have to attest that 40 is young. So anyway, I would say that listening to your presentation, the question that popped up in my mind was not, do we need to broaden the jurisdiction of the ICC or international courts to environmental crimes and economic crimes, but do we need international criminal jurisdiction at all? That was like, or should we switch to other models, as this one is obviously not working or not working as aspired. But I'm not going to use my moderating powers any longer. We already have 3 questions in the chat box, and I'm sure there will be some others, so maybe we should just turn to the questions that have already been posed. Hrvoje, do you want to pose the question yourselves, or do you want me? Okay, so you're here.
No, it's okay. Hello all. Well, you answered my question, part of my question, and it's a very broad question, and we still don't know the results of the US elections, but what do you think is the future of ICC, International Criminal Justice System, and especially in connection with the environmental and economic crimes? What will happen in the future?
Well, I'm now amazed. I see Sunchana from all sides. That's cool. No, sorry. Yeah, it's a really good question, which I am not sure I am able to answer, right? So what I would say, I think that the ICC is now very much struggling, has been struggling for the past 20 years now, given the current political context. I don't think it's very sort of prone or beneficial for the institution or any international institution for that matter. And as I said during my presentation, and that also, and maybe in particular, applies to environmental and economic crimes, I think that the future is domestic, honestly. And we see it also with atrocity crimes, but we also see it with environmental crimes. So for example, in the Netherlands, there have been a couple of prosecutions of environmental crimes done at the domestic Dutch courts with sort of a lot of success. And maybe I would say that domestic courts have maybe better tools to address these harms than the international criminal courts and tribunals.
Thank you for the answer. I don't know, Hrvoje, if you want to comment back. Just a comment from my side. Thinking about Dutch courts and their competence is one thing, and thinking about some other courts, I'm not going to name or shame any.
I agree.
No, but Maya, you raise a very, very important point as well, actually, I think. So in this sense, of course, how many domestic institutions are equipped and able to prosecute these crimes. So for sure, this is it. But like what I am afraid a little bit is that the International Criminal Court, and now I'm going to name aim and shame, is also not equipped and able to go after these harms. So what are we left with? Maybe we should go also beyond, yeah, criminal law, and not talk in criminal law terms, and maybe talk about different ways of dealing with these harms. Because also, if you think about it, you know, like putting in jail a perpetrator, what justice does it do for the harm caused by these crimes?
A lot of hard questions, and another one comes from Emma Mataga. Are you here? If not, I'm going to read it. What measures can be taken to make ICTs more effective and politically more independent?
What measures?
What measures?
Well, that's also
a simple question, right?
very complex question, and like honestly, I'm not sure, because I think that the crimes that they deal with are political. The aftermath in which they operate is political as well, and in a way they need to be political in order to operate in these very difficult contexts. So I really am not sure how to make them more independent. And if you think about it, you know, we are talking about international criminal courts and tribunals, but in the end, what it comes down to, they are staffed with humans, and humans are just humans. So in this sense, that's another thing which I think is also oftentimes not talked about when we talk about these institutions, are these individual little humans who are actually making up these institutions. And now I will go again to, you know, when I was at the ICC last year, I was really amazed how much it matters who you are and how you operate in order to sort of, you know, not in order to, but for the law that is being written. So these personalities very much matter. So I think that's also important to sort of realize when we are talking about these institutions. But how to make them more effective and independent, I think it's a huge question which I am unfortunately unable to answer, I think.
Thank you. You did answer. Another, I mean, Emma, if you want to jump in, please do. And if not, another question comes from Anna Maria Lukenda. Are you here? How does the ICC protect witnesses and victims who might be at risk on account of testimony given by such witnesses? So very concrete question, I would say.
Yeah. So the ICC, in the same way as the other tribunals, of course, has different protection measures for victims and witnesses. So there are different ways how these can be applied. You have voice distortion, identity, sort of hidden identities, relocation as well. There have been not so much research done actually into this because, of course, obviously these are confidential. But I think there is also, so I think that the victims are given protection. It can also go wrong. So for example, in Kenya's situation, you had a lot of problems with victims protection again, depending, I think, on the context in which the court operates. But there is also like a very different side to it, and this is, for example, now there is one trial going on at the ICC. It's a Mali related trial, and there all the witnesses are protected, and also expert witnesses are protected, which then sort of hinders a little bit the publicity of the trial. So in this sense, I think there are always sort of like competing interests that are in play as well. But there are protection measures, and I think that victims are given possibility to testify without having their lives or families threatened.
Thank you. I see another question, or not a question, But the raise of hands, so to say, from Nada Brewer-Ljubicic. Nada, please, the floor is yours.
Thank you, Maya.
That's you. Sunčana.
Thank you. Okay, Barbora, thank you. I have to ask you what I comment to end this lecture when he spoke about criminology of international crimes, right? So I have to start what we discussed during these days, that usually we have conflicts today in the areas which are rich with natural resources, which are very strategically important because we need to have new pipeline there, or some sort of economic security issue is going on in the region when the conflicts are present. Does it refer to whatever minerals or environmental crimes, etc.? So we have conflicts in the regions which are mostly poor and profitable in the same time. I mean, this is the reality right now. And based also what Andy was showing us and we heard so far, those economic, environmental, corruption crimes either can trigger new conflicts or are performed as a result of conflicts in that area. And we have all sorts of organized crime, international players, respected business, etc. present there. Though this is also the reality. We heard as well from our prosecutors, which I'm looking 3 of them in the room in Dubrovnik right now. We heard how it is very complex when we are talking that when we need to obtain evidence, when we have to cooperate, etc. And as I loved how you divided international crimes, and I can definitely sign these are the same characteristics when we are talking about serious, I'm not talking petty or ordinary, when we are talking about political white-collar crime. These are more or less, everything is intervened, we have more or less same players, complicity, etc., etc. Okay, guilt is another problem. And then we have calls from experts in UNODC, UNCAC, etc. This is why we are organizing this event, to bring all the experts together, that we need to find a better solution, how to have better mutual legal assistance, how to have better law enforcement, how can we more successfully address really transnational state corruption, state organized corruption, which has really devastating consequences, more or less the same chapeau elements as crimes against humanity and others have. So I'm in the Oslo statement, one of the possibility was detected that maybe expanding jurisdiction of ICC, I mean, it's a long subject already, would be one of the solutions. We are all aware that ICC has problems by themselves, but on the other side, if we are looking at international crimes that threaten peace, security, and justice, we cannot avoid crimes that are affecting economic, social, and cultural rights, as we heard from Anya, as well, especially now in COVID pandemic situation. Climate change is a new threat. I understand all of your comments, challenges, everything that you stated. I repeat, I agree totally. But maybe I want to be a bit of optimist here, especially when we are talking vast assets and lack of resources, which we can get by prosecuting, for instance, serious economic and environmental crimes. Do you think maybe that the ICC is really in sort of not really wanted position because ICC is no longer responding to the security threats and challenges to all human rights? Maybe this is the problem of ICC. Yeah, well, if I can get your comment a bit there, thank you.
No, yeah.
The lecture as everybody so far. Thank you.
Thank you, Sunčana, for this question. And I hear what you are saying, and you know, I think that one can look at it from sort of two different angles. So if we think about the ICC, and now irrespective of its functioning and all the challenges that I have sort of discussed, as a symbolic court, right? As a sort of like a symbol of what we as humanity consider to be the most serious crimes causing the most serious harm in our global community, then, and I think that this is also something where scholarship is a little bit heading to, because indeed there is a huge symbolic function in having certain types of crimes prohibited at the international level. In that sense, I would say yes. You know, yes, I think these crimes should be included as international crimes. When it comes to the practical implementation and enforcement, which is something that I have discussed and have been focusing, I actually, honestly, and I am, well, I'm not sure whether I am optimist, but usually I am quite optimistic person. I don't think that the ICC is solution, because all the problems that you mentioned, all the problems that I mentioned are there. And when it comes to large flows of money, I think that with the money comes power. And what we have witnessed by now is that whenever there is a power, the ICC backs off because it doesn't have the tools. It does not have. So, you know, my answer to your question, and I'm not sure whether it's satisfactory to you, is yes, on a symbolic level, I think indeed it would make sense, and then maybe sort of there will be this trickle-down effect to domestic jurisdiction, and these crimes will be prioritized more. So that's a very optimistic sort of take on. When it comes on a practical level, I don't think that ICC as an institution has resources and the power to go against the power. That's sort of my take on that.
Okay, well, thank you for that. I would sort of agree. I'm only afraid personally, you speak about symbolic value of incriminations on the international level, but I'm also thinking about the sobering realities that you mentioned. So you have aspirations on one side and then the realities on the other side. And in fact, it seems to me that sometimes it can even have a more negative effect, you know, by having all these aspirations put in one place and all these expectations, and then on the other hand, seeing that nothing is being done. I don't know, maybe it can even delegitimize the system further, but that's my view. I'm not sure. Any other questions at this moment from the participants? If not, I would like to thank you, Barbora. Mark, please.
Hi, can you all hear me all right? So I'd like to wish everyone a really good morning. Well, I guess I'm in the UK, so I guess it's an hour off. It's still barely morning here. And again, great regret that we can't all be together. I think that would really be lovely, but picking up on Barbora's point about optimism, I guess Zoom is better than no one in any room at all. So I guess this is great. So I mean, I have a reaction to Barbora's points on symbolism and the symbolic value of the International Criminal Court or international criminal justice more generally. I think it's indisputable that international criminal justice does carry with it considerable symbolic emphasis. But if that's the case, it means that the crimes that it is able to prosecute symbolically become demonstrated as the greatest harms that the international community faces. And anything that the International Criminal Court or any penal institution at all is able to successfully punish largely tends to be conduct that is deeply rooted in fault, individual agency, intent, exercise of free will, radical evil, to use Santiago Niño's point from writing about the Holocaust and violence in Latin America. So to me, I think there's a great danger, which is if we privilege criminal law as the mechanism by which to determine and stigmatize and symbolize that which is the most harmful to us, it means that we root ourselves in intentional free will violence. And it means that we exclude from that frame things, actions, inactions, as Barbora mentioned, negligence. And I really think we should ask ourselves an honest question, which is whether the greatest stability, security, human rights, and sovereignty threats that we face are necessarily motivated by intent, free will, and demonstrable evil, or whether the greatest challenges we face are actually caused by small daily acts of carelessness, selfishness, inadvertence, recklessness, or just social navigation, making the most out of what one has. And I think if you look at the most serious environmental concerns that the global community faces, it's not ecocide, it's not deliberate environmental modification, it's small daily acts. And so long as those small daily acts fall out of the symbolic power of that which defines the global community, we'll never identify an effective way to deal with them. So I think in this regards, international criminal law poses a risk. It tells us what is really harmful, and it has a very narrow band of harm. And the kinds of conduct that gives rise to harm that don't fall within the strictures of the criminal law end up falling nowhere, and then we can't really deal with them. And I think this is a bit of a bridge to something I might talk about tomorrow as well. But I think it's important for us to recognize that just because the ICC may one day in some fairy tale, some, glorious childhood story become successful, its success, ironically, may actually mean that more and more health, environmental, and economic harm simply knows no redress because it can't fit within the ICC frame. So I'm curious, Barbora, for your thoughts on that, or anyone else really. I remember from past times I've been with you all in Dubrovnik, it's actually been this much more free-for-all conversation as opposed to this sort of standard Q&A. So I'm very old-fashioned. I can't shed what I imagine to be actually being in the place at the time. So that's me in Zoom. Okay, bye.
Well, thank you, Mark. Yeah, I think it's very interesting, and it made me think about, perhaps it poses a risk, but perhaps it also is since all these harms that you were talking about involve us all, right? And we as a world saviors want to do something with the harms that threaten the whole world. So maybe international criminal law also cannot be extended to these harms, because then we would be considered as the perpetrators, actually. And in the way how international criminal law or its reach is now defined, it makes us feel good about ourselves because we are doing something about the biggest harms. So that's maybe another thing, as the international criminal law as a soothing mechanism for us in trying to save the world. So maybe it's something what people just do, what we do. I don't know. Because in a way, if you think about it, like all the conduct that you outlined, first, I don't think that criminal law is the means to address it, and second, then it will be a total overreach. But that's just me. Maybe there are other opinions behind the black windows.